Morning everybody, it's 10:05, so I am going to make a start. Thank you very much for attending our latest webinar. This one's on respect orders, how are they positioned as part of existing antisocial behaviour tools. For those of you that don't know me, my name's Kirsty Varley. I'm a partner and a higher courts advocate here at Forbes. I've always had a strong interest in antisocial behaviour in housing management. This is my 21st year working in the sector, sadly no time off for good behaviour. We're going to spend some time looking at how respect orders in their current form as they're drafted in the bill might fit into the existing toolkit that registered providers, local authorities and partner agencies have to tackle antisocial behaviour. Now, as we've got limited time this morning, I've cherry-picked really what I think are going to be the most salient and interesting points. There will be others, and no doubt as the legislation's implemented and the case law develops, we'll be able to revisit this further. I have left time for questions at the end and or sharing best practice and thoughts. Obviously, it's new and we all need to be able to sort of digest and chew the fat over what we think is going to happen. So there's time at the end of the session. Please can I ask that you use the Q&A function and not the chat box, just so that I can keep a track of all the questions that are there. If I don't have time to answer them now, I will get back to you after the session if you leave your contact details. So, apologies for this slide. Us lawyers love a disclaimer. I'm sorry, I can't help it. It must be in the DNA. As the slide says, it's generic advice. It's no replacement for specific advice that's tailored to whatever issues you're facing or particular queries that you've got. So, the fifth of the Labour Party's 6 steps for change in the manifesto in the run-up to the 2024 election, and this was to crack down on antisocial behaviour with more neighbourhood police, paid for by ending wasteful contracts, tough new penalties for offenders, and a new network of youth hubs. And within this, we saw the introduction of the Crime and Policing Bill 2024-2025. And in the 2024 crime survey for England and Wales, this found that 36% of all of those that responded had either witnessed or experienced antisocial behaviour. And that was a rise of 1% from last year. So, as we said, it's part of the government's Safer Streets mission. It's a key manifesto pledge. I've already touched on the crime survey, England and Wales data, and 36% really is a significant issue of all respondents. The government's view is that the existing tools to tackle antisocial behaviour don't go far enough. And so for us to have a look at this, first we need to consider the existing regime. I'm not including possession proceedings. The respect orders obviously are more akin to injunction orders. I don't think we'd have a very fair comparison in that way. So that's the reason I haven't considered possession orders in this particular session. So the existing regime to tackle antisocial behaviour, and this is what was considered by the government before they then went on to consider the respect orders. So firstly, the dispersal power. And this is the power which, as we know, enables police officers to direct a person who's committed or is likely to commit antisocial behaviour to leave a specified area and not return for a specified period of up to 48 hours. Now that's at present. There are plans for that to change. I think it's up to 72 hours in the bill. We then have the community protection notice. As we know, that's used for lower level, possibly environmental, antisocial behaviour. These are intended to stop persons aged 16 or over, or businesses or organisations from committing antisocial behaviour that has a detrimental impact on the community's quality of life. We then have the Public Space Protection Order, PSPO, and this is designed to stop individuals or groups from committing antisocial behaviour in a public space. They prohibit specific forms of environmental antisocial behaviour, such as public drinking or dog fouling. And councils issue PSPOs after they've consulted with the police and crime commissioner, the owner or occupier of land in the restricted area, and any other community representatives that they see fit. For example, it could be church organisations if it touches on church land. We then have the closure power, and as we know, this is to protect victims and communities by quickly closing premises that are causing or being used to cause nuisance or disorder. And the police officer or the local authority can issue the closure notice, and following that, the closure order can be applied for no later than 48 hours after service of the closure notice. We then have the criminal behaviour order, CBO. Used to be the old ASB on conviction. It's an order that can be issued by any criminal court against a person who's been convicted of an offence, to tackle the most persistently antisocial individuals who are also engaged in criminal activity. And then finally, our old friend, the civil injunction, sometimes known as the antisocial behaviour injunction or the ASB. As we know, these are civil behavioural orders. They're issued by the civil court. They're intended to stop or prevent individuals engaging in antisocial behaviour. They nip problems in the bud before they escalate. And the government's view is that civil injunctions are to be partially replaced by the new respect order. Now, the explanatory notes to the bill also refer to the community trigger or the ASB case review as a tool to tackle antisocial behaviour. I personally consider them to be more a way for the public to hold agencies to account if they don't think they're tackling antisocial behaviour, rather than a tool per se, which is why I haven't included them on the slide. So, a recap is, as we said, the existing regime, the civil injunction. So it's the most used tool in a landlord's armoury. It's certainly the reason I'm most in court, or most frequently in court. And as we know, it was introduced by the Antisocial Behaviour Crime and Policing Act in 2014. And part 1 is dedicated to civil injunctions, and that's from sections 1 to 21 of the Act. Now, for those of us old enough to remember them, they replaced ASBOs and previous Housing Act 1996 injunctions. The standard of proof is the civil standard of proof that's written into the legislation, and a breach of an order is a solely civil matter. So the contempt proceedings, arrested, brought before the court, can be imprisoned, but it's under the contempt regime. And it's not a criminal offence to breach a civil injunction as it was to breach an ASBO. And we're going to return to this later. So the Crime and Policing Bill 2024 to 2025, parts 1 to 9, tackle antisocial behaviour. And the bill itself deals with many more matters, but we're just going to be focused on these parts for today's purposes in the limited time we've got. Now, I checked on the Houses of Parliament website last night. The bill is currently at its second reading in the House of Lords. The session is due to sit on the 16th of October, so that's next week. So there will be further updates available after that, presuming that the session goes ahead and there isn't anything urgent that takes over. So before the bill becomes law, there are 3 further stages after the one next week in the House of Lords, and then 2 what are called final stages, which are consideration of any amendments that have been made by both houses, and then it will go to final royal assent. We don't know when that is yet. I don't have any information. It will obviously depend on how long the intervening stages take. So as we've said, the bill seeks to amend the existing Antisocial Behaviour Crime and Policing Act 2014, and Chapter 1 of the bill inserts Part A1 into the ASB Crime and Policing Act 2014. So the new Part A1 of the ASB Crime and Policing Act 2014 is going to look like this. It says the power to make respect orders. Subsection 1. A court may make an order under this section, so a respect order, against a person aged 18 or over, and this is the respondent, if A, the court is satisfied on the balance of probabilities that the respondent has engaged in or threatens to engage in antisocial behaviour, and B, the court considers it just and convenient to make the order for the purpose of preventing the respondent from engaging in antisocial behaviour. That might sound rather familiar. So, continuing on, subsection 2, a respect order may, for the purpose of preventing the respondent from engaging in antisocial behaviour, A, prohibit the respondent from doing anything described in the order, and B, require the respondent to do anything described in the order. Again, sounds rather familiar. The bill then states at subsection 3, prohibitions and requirements in a respect order must, so far as practicable, be such as to avoid any interference with the times, if any, at which the respondent normally works or attends any educational establishment. So if you are going to give someone a positive requirement, as with the civil injunction, don't have it interfering with the job or any education, whether it was school, college, university. Or B, conflicts with the requirements of any other court order or injunction to which the respondent is subject. So that one obviously does what it says on the tin. You can't really set somebody up to fail and make an order and require them to participate in a certain activity that's going to put them in breach with another court order. And part B1 subsection 2 of the bill describes who the relevant authorities are who can apply, and this is relevant for our purposes as it confirms that registered providers, local authorities are the relevant authorities for the purposes of applying for a respect order. So landlords can apply for a respect order. So respect orders generally, and I wanted to take a little bit of time to look through this because it was quite interesting. So part E1 of the bill confirms that applications can be made without notice. And it says an application for a respect order may be made without notice being given to the respondent. If an application is made without notice, the court must do one of the following. A, adjourn the proceedings and make an interim order. B, adjourn the proceedings without making an interim order. Or C, dismiss the application. Part C1 of the bill states that there is the power under a respect order to exclude a person from their own home in cases of violence or risk of harm. And a respect order can have the effect of excluding the respondent from the place where the respondent normally lives. The premises, this is referred to only if two conditions are met. So the first condition is that the order is made on the application of a local authority, the chief of police for the area that the premises are in. If the premises are owned or managed by a housing provider, that housing provider. And the second condition is that the court considers that the antisocial behaviour in which the respondent has engaged or threatened to engage consists of or includes the use or threatened use of violence against other persons, or there's a significant risk of harm to other persons from the respondent. So the test that we're used to with exclusions for civil injunctions pretty much mirrors that. Then we go on to part D1 of the bill, and requirements can be included in a respect order. So the bill says a respect order that includes a requirement must specify the person, and they're called the supervisor, who is to be responsible for supervising compliance with the requirement. The supervisor can be an individual or an organisation. Before a requirement is included, the court must have evidence about its suitability and enforceability. And this evidence has to come from either the individual specified as the supervisor or an individual representing the organisation if the organisation is specified. And before including 2 or more requirements, the court has to consider the compatibility with one another. And where the court includes a respect order, a requirement, the effect of which the court considers requires the respondent to participate in a particular activity, the court has to declare the requirement to be an activity requirement for the purposes of this part, and the order must specify that the court has done that. Then it's the duty of the person specified as the supervisor to make any necessary arrangements in connection with the requirement for which the supervisor has responsibility. And also to promote the respondent's compliance with the relevant requirements, and to inform the person who applied for the order and the chief police officer if the supervisor considers that the respondent has complied with all relevant requirements. So moving on to F1, interim orders. So this section applies where the court adjourns the hearing of an application either on notice or without notice of a respect order. And the court can make a respect order that lasts until the final hearing of the application if it considers it just to do so. An interim order made at the hearing of which the respondent wasn't given notice, so without notice interim hearings can't have the effect of requiring the respondent to participate in particular activities. Subject to that, the same powers available in relation to an interim respect order as it has in relation to a final order. So again, as with civil injunctions, while you can have positive requirements, you can't have them on a without notice basis, is effectively what that paragraph is saying. And then finally, moving on to G1, variation and discharge of orders. The court can vary or discharge a respect order. This is only on the application of either the person who applied for the order or the respondent. And the court in this section means the court that made the order. So you've got to go back to the originating court if you want to vary it. And the power to vary an order includes the power to include an additional prohibition or requirement in the order, or to extend the period for which a prohibition or requirement has effect. And if an application to vary is dismissed, the party who made the dismissed application can't make any further applications without the consent of the court or the agreement of the other party. So this again mirrors what we see with civil injunctions. So respect orders versus injunction orders, what's new? So having looked through the bill, thought about how we use civil injunctions in practice, what the rules are, etc. These are some things that I've picked out as being different and things that we're going to have to get our heads around. So firstly, part A1, a court can treat an application for a respect order as an application under section 1A, the power to grant a housing injunction, for an injunction under that section. So what that means is you may go to court as a landlord asking for a respect order and get an injunction, or asking for an injunction order and get a respect order. That may be worth thinking about in terms of how you plead your case if you have a specific preference and there's a reason for that. Obviously, we'll have to see how that plays out in practice. So H1 of the bill, this is a duty to give a warning for a breach of an activity requirement, so a breach of a positive requirement. So this section applies where the supervisor responsible for an activity requirement is of the opinion that the respondent has, without a reasonable excuse, failed to comply with the requirement, and the respondent has not been given a warning under this section in relation to the requirement within the period of 12 months ending with the date of the failure. So if they've not been warned in the previous 12 months that they think that the injunction, the positive requirement to the injunction has been breached, the supervisor has to give the respondent a warning in relation to the requirement. It's got to be in writing, and it's got to describe the circumstances of the failure to comply. And it must also inform the respondent that if the respondent breaches the activity requirement again within the period of 12 months beginning with the date on which the warning is given, the respondent's liable to prosecution under section I1, which I'll come on to in a second. And a warning under this section can be given to a person by hand or by sending it by first class post to the person's last known address. So no requirement for personal service there. And as soon as practicable, after giving a warning under this section, the supervisor must record that fact. So that is something that's new. It's not something we have to do under the current regime, although a lot of landlords do it, and registered providers, local authorities doing it, you know, as a matter of practice, warn people, but it isn't a requirement. It is going to be for a respect order, and that is probably because of what I'm going to tell you now about I1. So under I1, and this is the criminal offence, it's an offence for a person without reasonable excuse to do anything the person is prohibited from doing by a respect order, or to fail to do anything the person is required to do by a respect order. So subsection 1B doesn't apply in relation to a failure to comply with an activity requirement unless within the period of 12 months ending with the date of failure, the person's been given the warning under section H1, which we've just discussed, in relation to the requirement. So if you've not had a warning in the previous 12 months, you can't have a conviction. You've got to have that warning first. A person who commits an offence under this section is liable to, on summary conviction, a term of imprisonment not exceeding the general limit in the magistrate's court, or a fine, or both, and on indictment to a term of imprisonment for a period not exceeding 2 years, or a fine, or both. Now, I checked the magistrate's court limits this morning, actually, and they were increased from 6 months imprisonment to 12 months imprisonment in November of last year. So the magistrates can send somebody to prison for up to a period of 12 months now. As the Crown Court has the power, though, to sentence somebody for a period of up to 2 years, that's the maximum under the law. I would imagine defendants are going to be seeking, certainly if they're convicted, to have the sentence sent to the magistrate's court, because they're exposed to less potential time in custody. And also, interestingly, where a person is convicted of an offence under this section, it isn't open to the court by or before which the person's convicted to make, in respect of the offence, an order for a conditional discharge. Now, a conditional discharge is one of the lowest sentences that a court can give. Aside from being acquitted, really, a conditional discharge is pretty much sort of, you know, you've been convicted, on your way, off you go. That isn't available here. So, breach of a respect order in more detail. Obviously, while there are differences, I think I would certainly argue that the key one is breach of this order is a criminal offence. So that, I think, is the biggest difference. So, issues likely to arise. Is there going to be possible reluctance from the court to impose respect orders and risk criminalising a defendant? Well, the courts and the judiciary are going to receive extensive training on this after the commencement date and the bill becomes law. And they are going to be acutely aware that if they impose an injunction to curtail antisocial behaviour, a proven breach of that could lead to a custodial sentence and a criminal offence. So it's very different from them sending somebody to prison for a contempt of court, which is under the civil regime. That does not appear on a person's criminal record. Also, contempt can be purged at any time. So that means if the person in prison writes to the judge, apologises, and is sufficiently contrite, a judge can release the person from prison before the sentence is up, and I have seen that happen. So, is this going to be a case where judges, when faced with a decision, do I make a respect order against this person? Do I make an injunction order against this person? is this going to weigh in the judge's mind, particularly if the defendant doesn't have a criminal record already? Yes, I want to tackle the antisocial behaviour, but do I want to expose this person to the criminal justice system and potentially give them a criminal record for the first time? That is going to be something, I think that is going to be a factor in whether courts will make respect orders and, in fact, which order they choose to make. In terms of defence challenges, so as well as defence solicitors potentially arguing the point that I've just made about not criminalising the clients, there is the distinct possibility that we'll see challenges to the standard of proof that's set out in the legislation by Parliament. I recently did an article for Resolve ASB on this issue, and I touched on this. So again, for those of us old enough to remember, the old ASB was a civil remedy, and that was brought on complaint in the magistrate's court by the police or a local authority. Or it could be made as what was termed a bolt-on remedy in addition to other proceedings such as injunction or possession proceedings by a landlord, including a housing provider in the county court. It wasn't done often, but I have done one or two in my time. Now, the civil standard of proof was adopted because the ASB was a civil remedy, and custom and practice tells us if it's a civil order, the civil standard of proof applies, which means it's more likely than not, commonly described as sort of 51 to 49% if we're weighing in the balance. This was challenged in the Crown on the application of McCann and Manchester Crown Court in 2002. And after multiple appeals, this case confirmed that while the proceedings were civil in nature, because the ultimate sanction on a proven breach was criminal, then the appropriate standard of proof for the civil proceedings was effectively the criminal standard. So arguments around human rights, right to a fair trial were used amongst others. But ultimately, the court decided that the standard of proof required to obtain an ASB was held to be the criminal standard. And I would describe that as we're in the civil court as being the same standard as when we attempt to prove a breach of an injunction. So we're looking at the criminal standard for contempt proceedings, and that was the standard we had to meet at the time in order to obtain an antisocial behaviour injunction, not a breach, because that was criminal anyway. You had to meet that standard just to get an ASB after the McCann case in 2002. So I suppose the difference is the standard of proof was never required to obtain an ASB was never determined by Parliament. It was never enshrined in the legislation, as it currently is for civil injunctions and as it is in this bill for respect orders. But the ultimate sanction for a breach is criminal, I can foresee challenges to this once the bill is enacted into law. Breaches being misunderstood or not actioned appropriately. Well, we've all had the frustration where we've had a breach of injunction order, either the arrest is for a term of the injunction that doesn't carry the power of arrest. The person is arrested and taken to the wrong court. The person is arrested for a criminal offence. The person is arrested and bailed. The person is arrested, interviewed under pace, and the 24-hour clock runs out. These are all frustrations that we have already with the existing regime. And this is where we have some input into this and some control, if you like. When we move to the respect orders, breaches are completely within the remit of the police and the CPS for charging decisions, and us as applicants, we're not going to get very much say at all, other than perhaps to give evidence to the police about the circumstances of the breach and why the order was made. But there will be no decisions to be made about potentially stopping proceedings, discontinuing, coming to some settlement and agreement. All that will go with the respect order, because that is a criminal offence that enters the criminal regime. And finally, on this slide, the delays in the criminal justice system. They are well documented. There were some delays anyway. COVID had a devastating impact on the criminal justice system. I'm aware of some criminal matters now that have been for their what we call plea and case management hearings, which are like the equivalent to our directions hearings, and they're getting trials in 3 years' time. So how long are we going to have to wait for these convictions? And finally, before I open up the webinar for any questions and or best practice, some practical considerations. So how do we make an application for a respect order if we want to make one? Currently, Civil Procedure Rule 65 governs any antisocial behaviour proceedings, civil injunctions, gang injunctions, other types of injunctions. That currently governs the system and the regime that we're working under. That's going to need to be amended. The statutory guidance that is in existence in relation to tackling antisocial behaviour will also need to be updated, and that was only updated actually in July of this year. So that's going to need to be updated again. Further revision, obviously, when the new powers come in. Legal aid. I've spoken to some of my defence practitioner colleagues, and they're really very concerned about whether the legal aid rules are going to be amended in time, whether anybody's going to think about this, so that proper funding can be established for defendants. Access to justice, obviously, they're concerned about that. And from our perspective as well, I mean, I would say it's in everybody's interest, really, for the funding regime for legal aid to be sorted out and for these matters to be ironed out before the respect orders actually become law, because what we don't want is us to make an application for a respect order, whether it's without notice or on notice. We get to the first hearing, we've got to adjourn for legal aid, We know how frustrating that can be, adjournments anyway, so we really do need that to be the government to be hot on that and to sort that out along with the legal aid agency. And finally, just a bit of food for thought. As I was reading through the bill, I noticed that a breach of a respect order is going to be a mandatory ground for possession. Now, this obviously is good news. That's what we would hope. If it's going to mirror and run alongside a civil injunction, which is a mandatory ground for possession, then we would want a breach of a respect order to also be a mandatory ground for possession, and it's going to be. But at the last time of checking the bill, this is inserted into ground 2 of, condition 2 of ground 7A of the Housing Act 1988, and not ground 1. So ground 2, as you'll probably know, is the ground that relates to breach of a civil injunction order. And if you get a proven breach, that then gives you the absolute ground for possession. But condition 1 relates to serious criminal offences, and there is a list, there's a schedule of the offences. It's attached to the Housing Act 85, one of the schedules there. And I just found it interesting, if these respect orders are as important as the government say, and they've gone to the trouble of making them a criminal offence, why would they not put a respect order on a breach of a respect order, which is a criminal offence, on the schedule of serious offences, and not and instead put it alongside a breach of an injunction order? And I just wondered whether it was because they were trying to preempt some defence challenges to this. So as I said before, with the Manchester and McCann case, the challenges that were made were that a person was being exposed to a criminal offence for breach of a civil order. And I just wonder if the government felt it might have been a bit of a step too far to include the criminal offence as a serious offence rather than just including it alongside the breach of the injunction order. And the practical effects are the same. It gives us an absolute ground for possession. But I just wondered if this was the government's way of saying, well, you know what, even if you'd had an injunction order and breached that, you'd still be under that mandatory ground. That just, as I say, it's just a bit of food for thought, but I found that quite an interesting facet really in the bill. So obviously be very interested to see what you think. I can see we've got some questions, so I'm going to move on to these. On the chat, I do apologise, I did miss a slide out. That was down to me. Sorry, I got so carried away. Okay, so I've got some, I've got a question here from, oh, I'm sorry, Selena appears to have lost sound. I do hope that that was sorted out for you. I think it's been recorded anyway, so I'm sure we'll be able to send that out to you. Got a question from Linda Cole. If you have to give a warning letter prior to an offence for a breach being committed, how does that fit / compare where currently an ASB can contain a power of arrest and the defendant can be arrested and then brought to appear before the court within 24 hours, can be held in custody up to 8 days while the contempt application is made? That's a really good question, Linda. So what the bill is saying is you couldn't arrest somebody for a first breach effectively of what is a positive requirement. It's, the requirement activity is positive requirements, the same difference. You've got to warn them first, and then if they breach it again, if there is a power of arrest attached to that, well, you won't have a power of arrest actually, of course, because it's a criminal offence, isn't it? So what you're doing is you're writing to the person first, you'd be telling them, you've breached this, we believe that you've breached this. You then, I imagine, need to lodge that with the police in a similar way that we do with a power of arrest. So you'd lodge the warning with the police, and then if there was a further breach, the police get involved and it's a criminal matter. So they're not brought before the court within 24 hours. They're not held in custody with up to 8 days. It's the criminal regime. So the Police and Criminal Evidence Act applies. They can be interviewed. They can be remanded in custody if that is what is decided, and the Bail Act applies. So everything that we know in terms of committal applications just falls away. So I hope that answers your question. Is there an idea of the date that the bill reaches assent? I wish I knew that. And again, with the updated guidance, as I say, the next stage is next week. I am subscribed to the Houses of Parliament, so I do get alerts when different things happen, different stages of the bill go through. So I will be happy to communicate that. I'll put it on LinkedIn, my social media, etc. So when I know any more, you'll know. I've got a question from Liam Clark. With the criteria being so similar to civil injunctions, are we anticipating a reluctance from judges to issue respect orders and stick with injunctions? I am, actually, if I'm being perfectly honest, for the reasons that I said. I think some judges are going to look at this and think this is ASBO 2.0, as some of us old enough to remember them were calling them. ASBOs were done away with and civil injunctions were put into place quite some time ago now. And as I said, our judge is going to look at somebody and think, if I give you this order, you're not only are you going to go and you breach it, not only are you going to prison, you're going to have a criminal record. Especially, as I said, especially if the person isn't in the criminal arena, doesn't have a record. Is a judge going to want to do that to somebody? Because you're affecting somebody's life, not just after the injunction, not just after they've served any prison sentence or any suspended sentence or paid any fine for a breach. That conviction could follow them around for the rest of their lives. So I do think we're going to see some reluctance, if I'm honest. And I haven't spoken to any judges about it. As soon as I can, I will. But that would be my view. If I were a judge, I would be looking at this and thinking, do I really want to punish this person for the rest of their life? So that, I think, is something we'll have to look at. I've got a question from John Malloy. How can this legislation enforce a subjective value like respect through a criminal sanction, especially when the respect order risks being legally challenged for vagueness and fails to address the root causes of antisocial behaviour? Having been in housing 30 years, well, you beat me there, John, by 9 years, and recall that ASBOs failed for similar reasons, what actual evidence supports that this new order will succeed where others have not? I think the answer is none. I was in Parliament for the launch of the ASB Awareness Week, and I was speaking to quite a lot of people there, some very senior police officers, a couple of King's Counsel, and I think they all thought the same thing. This was a manifesto pledge. A lack of respect is something that is often discussed, but as you rightly say, John, what is respect? What one person considers respect? It's subjective, isn't it? what you consider to be respectful, I might consider to be something completely different. So there's no evidence, but it was a manifesto pledge. It's something that the government are very keen on, and it's coming into force. So we'll have to see what happens. I think the fact that they're not getting rid of civil injunctions altogether is quite telling. And from what I understand, some of the evidence that they received basically said what you said, which is that we're quite happy with the toolkit that we've got. I think the only positive for me in respect orders being a breach being a criminal offence is that the sentencing options that opens up are much wider than a court has, much wider. So a civil court really can only send you to prison, give a suspended prison sentence, a fine, adjourn it generally. They're very limited, and none of those things, none of those options address any underlying potential issues that the person has, whereas in the criminal arena, they've got probation, they can go on treatment programs. That is the positive thing. It's just a shame for me that they won't open up the probation service and give the county court the ability to access those things. That, if I had a wish list, that would be right near the top of mine. That was a really great comment, thank you. So, excuse me. Tess Ash, morning Tess. Struggling to understand the real difference for RSLs who are already using the injunction to challenge ASB. Totally agree. Totally agree. You and I are long enough in the tooth, as we both remember the ASBO. I know we do. I think the civil injunction is a good tool. I think it works well. And as I say, as I've just said, that would be my only wish, that we could access some of the probation services to tackle underlying root causes of ASB. But we can't, and the probation service being as stretched as it is, I don't think there's any potential for that anytime in the future. I've got some more. From what you said, the local authority gets the respect order, but any breach criminal proceedings will be for the police or CPS to prosecute. Yes, that's right, because the breach is a criminal offence. So you can do all the legwork if you like. You can get your respect order in place, and then any breaches you'd report to the police as a criminal offence, and then the police take over, and you effectively lose, as we said, any you've no skin in the game, if you like. You can't influence anything in any way. You may just be asked for witness statements about the reasons for the injunction and for the respect order, sorry, and circumstances of any breach if you're aware of them, but you would just be a witness in the proceedings. You've no standing, whereas at the moment you're the claimant, aren't you? So that's right. Linda, so do you only need a warning letter for a positive requirement? Sorry, Linda, no. So if that wasn't clear, apologies. The warning letter relates to a breach of a positive requirement, and before that can be actioned and prosecuted as a criminal offence. So if somebody has a positive requirement and they haven't complied with it, and they've not had a warning letter within 12 months, you've got to give them a warning first. And then if they breach it again within that 12-month period, when you've given them the warning, then they can be arrested. That's a criminal offence. Question from Lauren Howard. Do all breaches require the written warning? Or if the breach is serious, can they be processed for the breach right away? No, it's just breaches of a positive requirement. Because that, I suppose, if you will look at it in the round, a breach of a positive requirement, you might have just not gone to an anger management class. That is not the same as going and threatening somebody who the respect order is designed to protect. And there could be a good reason for that. You could have been ill, your child could have been ill, you could have been in hospital, you might not have got the appointment. So that's why you get the written warning for a breach, just for the positive requirement. Other breaches, criminal offence, dealt with in that way. Another question. Police are often reluctant to involve themselves with breaches of CPOs. Will it be the same here? I did say some potential issues and how breaches are dealt with. I would hope very much, given that it's going to be a new criminal offence, the police and the College of Policing are going to be hot on this. I am speaking to them actually about various different things, so I am going to be in touch with them about this and offer some training. I would hope that because it's a new criminal offence, they're going to get involved in it. I think the reluctance sometimes that we find with injunctions is they don't really understand them. I've done training going back, I don't know how long, and you just couldn't get the head around the fact that, no, you don't interview them, no, you don't take them to the magistrate's court, just arrest them, let us know, take your witness statements, do your arrest statement, bring them to court, and we'll do the rest. So I'm hoping that because it's a criminal offence, there will be more buy-in, if you like. Joanne McNamara, will there be transitional arrangements for existing ASB in the county court for future breaches and contempt proceedings and directions for opposed applications where the final hearing is months away? They're not seeking to replace the ASB altogether. So if you've got an existing ASB, that will run alongside it. It's not the same as it was when ASBOs just went completely and we had to have transitional arrangements there. Your ASB will still continue. The ASB Crime and Policing Act, Part 1, as it is now, is going to remain in force. There's just going to be a Part A1 that runs alongside it that allows either the respect order or the civil injunction to be made. So I don't think that that's going to affect that. Liam, last question. That's fine, Liam. I'm here as long as you need me. As our role is to ultimately resolve ASB, I'd appreciate thoughts on preferring an injunction to allow a breach in court and obtain grounds for a mandatory possession a lot faster than waiting for a criminal conviction due to outline delays in criminal courts. Agreed. And these, I think, are going to be things as landlords, as registered providers, as local authorities, you're going to want to think about. Not just, as we said, losing control of the breach, losing control of any, if you've got possession, I mean, this happens quite a lot. If you've got committal proceedings and possession proceedings, there can be negotiations to be had there, can't there? That will go, won't it, with a respect order, because it doesn't matter what you say in terms of the breach. The breach isn't up to you. The breach is up to the CPS and the police. So there will be cases, I'm sure, where you think the respect order is the right thing to do. But these are, I think, considerations that you really need to keep in the forefront of your mind when you're making your applications to court. Morning, Claire. Claire Taylor. So this is a concern that GMP will have control of any breaches of our respect orders. It's difficult enough to get GMP to take action when crime is currently being committed, or when civil injunctions are breached, when there's a power of arrest due to lack of resources. Well, yeah, I mean, I agree, Claire, and you and I have had this conversation, haven't we, on many occasions. I think, as I said, well, I'm certainly hoping that because it's a criminal offence, there'll be more buy-in, there'll be more understanding. It's just that, as you say, you've lost control of it. You've got the order, but any breaches, they are policed by the police. They're not policed by you. So that is something that you're going to need to think about. We'll have to wait and see. Hello, Liam. Don't make promises you can't keep. One more question. Can you apply for both? An injunction is in place. Can you request a respect order if breaches don't have the desired effect? I don't see why not. I don't see why you can't do that. I don't see why you couldn't say to the court, we have tried an injunction, Judge. It's not working. We'd like to convert it to a respect order because we think that the criminal sanction that is going to be, the defendant's going to be exposed to, is going to be more of a deterrent than the contempt one. And they're going to have a criminal record afterwards. And we're going to warn them of that if they don't stop breaching it. That is a good idea. And that I think may get some buy-in from judges if you've tried your injunction order first. You've not done what we said, which was expose the person to a potential criminal record, but then it's not worked and they keep breaching. You either, especially if they're not a tenant and you can't look at a possession order, what else is left open to you? So that might be a nice thing to try. So if a written warning is issued with, say, 6 months of the 12-month period, is that time extended or would it continue? So the written warning is issued. If there are any further breaches, 12 months from the date that that's issued, then they're prosecuted. So it's effectively like when you send a NOS, we've got 12 months, haven't you, to issue proceedings. It's like that. It's a 12-month timeline, and it's a straight line in time, effectively. It won't be extended, no. So if the person breaches, as I say, they're going to be arrested and prosecuted. If they don't, and they breach again within 12 months and 1 day, you've got to do a new warning. Caroline Lacey, morning, Caroline. Appreciate the training. Seems a bit of a conflict of new order, and will the courts grant them? Yeah, agreed. As I say, as soon as I get the chance to have a chat with a friendly judge, I will do. Obviously, I'll keep people updated just to try and gauge what the judiciary's view is. Well, it's one of those. We'll have to wait and see. So, I've got an anonymous question. You mentioned some defences. Yes. Quality Act defences. Yes. Would it be the same with the respect order? Absolutely, yes. So what I tried to do here, obviously I've only had a limited amount of time, was to look at the current regime as it is, how the respect order is going to fit in there, and just some key differences. But absolutely, Equality Act defences, you're going to face them all, aren't you? Anything that you do as an organisation, the Equality Act potentially could apply if the person's got a protected characteristic. So you're always going to face that. Absolutely, yeah. I'll just see if there's any more I haven't answered. Another one from Claire. I anticipate formal complaints will increase due to no longer having control of the case. If breaches are committed, it will be difficult to try and manage witnesses' expectations. Yeah, I agree with that too. It may be that there are some breaches that you as a housing provider would have proceeded with, that the CPS decide they don't fancy doing. And that will just be tough then. There'll be nothing we can do about it. So yeah, I mean, I agree with that. And as I say, the losing control of the breach aspect for me is something that you really want to consider. I'm just going to check if I've got anything else. I'm really pleased with all the questions today. It's been great. It's been really interesting for me to look at this. Obviously, you go on courses and you sort of think how it's going to fit in, but actually sitting down and working out how these two things are going to run alongside one another. I'm not sure I'm a fan. I think I'll just leave it that. We'll have to see what happens. And I think there might be one more. Do we have a question from Molly? You had a hand up? Just let me check. I think that's all the questions, unless there's anything else. I think we will end the webinar. Oh, there's a question from David. What are the benefits over seeking, apologies David, I didn't see that. What are the benefits over seeking designation from the local authority and using CPNs? Well, it's similar, isn't it? Because again, the breach of that, you don't have control of either. So your order, I suppose, the respect order itself, it's going to carry more weight, more gravitas because it's a court order. The person's been in front of a judge, they've been told, they've been served with the order. The term of imprisonment is greater. It's fines, isn't it, for CPN? So you're looking at up to 2 years in prison. So, but again, it's the loss of control, isn't it, that I think is going to be key for people to factor in what they think is the appropriate course of action. Right, I think I've answered everybody's questions now. So thank you so much for joining us. Apologies for the slide sticking and not moving on. Hopefully you could make sense of what was being said. This has been recorded anyway, and we can send the slides out. Thank you so much for attending, and have a good day.